I don't know, gigantic. It's not, it's not about keeping them busy.
Your show will go live in 5 seconds. 4, 3, 2, 1.
Well, welcome. Good Monday morning, episode 195, Business and Legal Week in Review. This is UTLRadio.com, your business success and legal information station. I'm your host, Peter Lamont. My co-host here, Bob Hughes. Got a lot of things going. Good morning, Bob. We got a lot of things going on. We've got Supreme Court back in action. We can talk about some of the issues that they're going to be looking at: voting rights, abortion, affirmative action. Got the Batmobile. I mean, who could not use a little dose of news about the Batmobile, right? Got a lot of stuff.
Now, have you seen that the old Batman shows are on, like, I think it's Me TV, which is this new kind of these new 2 or 3 stations that are around that are specializing in classic television. So kids are a big fan of the old Batman, and the onomatopoeias are always fun.
Oh, Batman's awesome. I picked up the DVD set of the old show for my my kids. They love it. For me, like, you can't beat the old Batman.
No. Can't be, of course, but entertaining always.
That's right. But there's something to be said for that, because I think we're missing some of that.
Sure.
I like the villains were cool. It was fun.
That's right.
And we're going to talk about the Batmobile today, but I remember being in New York City. I was down at a car show. It was by chance because I'm not a car guy. But me and my kids and my wife, we were down there on Wall Street just looking. When I used to work down there, we went into my office, and they had the Batmobile, like one of the Batmobiles. Yeah. And I remember my son was like too close to it. And the guy who owned the Batmobile, I thought he was going to have like an aneurysm. He was like, no. So.
You're breathing on my car. Yeah. Spinal Tap. Don't even look at it. It's not for play. No, don't touch it. Don't even look at it. Don't pull me.
That's exactly how it was. Yes.
There you go. So yeah, that was an interesting. But as we talk about the story, when we get that far, a lot of it makes a lot of sense.
Totally does. We've got a bunch of other things going on as well, and we'll talk about some of that later on. We have some news from last week. We had a really, really great interview last Thursday. That's available on YouTube, and we'll talk about some of that. But let's get into the stories, because we do have a lot to get through today. So I'm going to turn it over to you, Bob.
Oh, absolutely. Here we go. Hollywood back at it, but this is something that's near and dear to my heart as a freelancer. Hollywood Reporter, the publication, now facing a class action suit from freelancers, says a judge, according to Deadline.com. The Prometheus Global Media Publications dispute with a former freelancer just took on a whole new form, one that could really open the books on the way the Hollywood Reporter and probably a lot of other companies do business. In a pivotal hearing on Friday, Judge Jane Johnson issued a ruling certifying a nearly 2-year-old case against the company and the trade mag into a class action that will face a jury at trial. Now, that means the Prometheus and THR will have to face an estimated more than 40 class members who say the mag intentionally played a shell game with their employment status, a situation that was referred to as the defendant's illegal common policies and practices in the original suit. The time period covered by the class certification is from January 2010 to the present and is specific to those freelancers who were paid by the hour and were provided all the trappings of full-time employment, such as company emails, office space, company phone numbers, and computers. Now, this was started by longtime THR contributor David Simpson's filing on September 27, 2013, alleging that freelancers at THR are indistinguishable from employees in all material respects, and that the sole purpose of misclassifying freelancers as independent contractors is to deny them benefits and protections afforded to employees. Now, it's worth noting that on the THR site back in 2013, freelancer Simpson was referred to as THR staff and an assistant editor. Now, seeking the class certification, Judge Johnson, that is, she is granted under the California Labor Code, the initial 7 claim complaints seeking unspecified financial damages from THR stemming from not being paid overtime, delays in getting paid, lack of itemized work statements, and, of course, no benefits. The complaint also sought an injunction requiring THR to classify their freelancers as employees and provide said employees with coverage under California worker compensation and unemployment benefits. An amended complaint was filed in January of this year in the matter. In the previous court paperwork, the defendant said that they had reached settlements with 14 of the then potential class members. Though that plays no significant role in the certification process, according to Judge Johnson. The next stage of the case is a status hearing scheduled for December 3rd. A lot of people are going to freelancing today. Now, this is, I sit here and do my freelancing in beautiful mid-Michigan. Not everybody has that benefit. Some people go to work, and that's where this is going to start to bite companies right in the butt. Are you seeing a lot of this, Peter, in the New York area and the East Coast?
Oh, definitely. And I think the problem that we see is that people are either, companies are either on
here.
What's that?
Gosh darn it.
Can you hear me, bud? Wait, hold on. Can you hear me?
Oh, there I am.
You go.
Yes,
okay.
I was about to start redialing.
No, there we go. All right. So anyway, now
put the banana down.
Sorry to answer your question. I see it a lot on the East Coast, and it really stems from two things. Either A, the companies are not aware of what they're doing, so it's ignorance, or two,
Sure.
It's intentional. And I see the intentional side of this, unfortunately, more than I see the accidental or ignorant side. So there's a lot of companies that will come in and they'll say, listen, nobody's going to know, we're going to treat this person as an independent contractor, treat them as a freelancer. I'm going to pay you off the books, or I'll pay you this way, or I'll 1099 you. And then they try to get away with it, and they do, because it's very hard to crack down on it. But then you'll find that one company that does it so blatantly that it draws attention. Then there's a big investigation, and then all these other little guys are worried. But really, I think that what this suit highlights is the fact that you can't hide forever. And if you've not been caught now, at some point, you probably will be. And it's just not worth it. So either A, educate yourself as to who is an independent contractor and who is an employee. And don't try to get away with something, because all it takes is one disgruntled freelancer who deems him or herself more as an employee, and then they bring an action in the state. It doesn't cost them any money. They go to the labor board, and you have a serious problem, because the labor board will look at all of your records and employees and freelancers the same way they're doing here. So that's
always fun.
Yeah, it's just, it saves you money up front, because you just have to 1099 these people, right? And that sounds very appealing. You don't have to pay employment tax, because up here in New Jersey, employment tax is just ridiculous. But taking a shortcut is going to land you in so much trouble that if you do get caught, you'll be out of business. I've known people up here that were doing this on a broader scale, and they ended up bankrupting the entire company. Everything they put years working into. So I would say this: A, you need to be educated. If you're going to start using freelancers, you need to speak to your attorney and to your accountant and figure out who qualifies as an independent contractor or freelancer, and whether or not you can pay them on a 1099 versus having them as employees and having to offer them benefits. And unfortunately, sometimes you have to have these people as employees, and it might limit your ability to add to the staff, because it's expensive paying for benefits and that sort of thing.
Sure, absolutely. Actually, what's interesting in line with this? I know of a company, who shall remain nameless, that has individuals working for them as subcontractors, 1099s them, but pays them $7.50 an hour contract wage. So they're paying sub-minimum wage because they're contractors.
Yeah, and that's a problem.
Well, and I didn't know how, if I'm me, do I have to pay me $8.20 an hour, whatever the minimum wage is? Because I'm my own contractor, my own employee. How much trouble could someone get in for that?
It really, really depends. Well, it depends on what you're doing. So let's say you're going to go virtual and you're going with like a virtual assistant and you are dealing with somebody in, I don't know, Indonesia. And so $5 an hour for somebody in Indonesia is significant.
Oh, sure.
You can't get in trouble for that, okay, because you're using this virtual assistant and, you know, if you're using them through a company, then you're paying them through that company and you don't have to worry about it. That's different. The problem is really where you are trying to avoid minimum wage or any sort of benefit payments. If you're avoiding those laws by creating this subcategory of either independent contractors, subcontractors, whatever you want to call them, and it's a deliberate attempt to avoid payment, then you could have problems. And what could the fines be? Well, it generally would go to your state's Department of Labor. They'd look at what taxes you've paid and haven't paid. You could be hit with a retroactive tax bill. You can be fined. And if it looks like it's a more widespread issue, it can trigger federal law. And then you've got serious problems. But, you know, the way you do it is to have an understanding of the independent contractor analysis. Can you bring a subcontractor on and contract with them to pay them less than minimum wage? Theoretically, yes, which is the example of the virtual assistant, but it has to be done in a way that doesn't look like you're deliberately trying to avoid paying them a salary. And, you know, again...
and that's exactly what these people are doing.
Right, and that's a problem.
Exactly what these people are doing.
Now, the other problem that people run into is that they'll sometimes hire an independent contractor, and that independent contractor is doing exactly the same work as salaried employees. And there's a test. Like in New Jersey, there's a 3-pronged test that you have to go through to determine whether or not you're an independent contractor. If you don't qualify as an independent contractor, the fact that you can get away with paying them that way for a very long time doesn't mean that you're not doing something wrong.
Well, these people are actually showing up on site. There are no actual employees doing the jobs they're doing. They're all contractors. And let's say they're putting cookies in a bag and then zipping the bag shut.
Right.
That's their job. They stuff cookies into bags. And that's what they do. And they do it on site in a company facility. And they do it for less than minimum wage. When I found that, I went, you got to be kidding me.
Yep.
And you people allow it?
Well, you know, it's what part of the test. Part of the test in most states is whether or not you as the employer are exerting control over the employee. And if you're having the employee come to your facility, work with your, like in this example of the cookie stuffers, work within your health code or your requirements, doing the job as they direct, because a lot of it comes down to direction. If you are free to go take a client and deal with them on their own, like if you were more of a freelance accountant, that's different. You make your own hours, you go do your own thing. But when you exert direct control and you know you're essentially their employer, then that's wrong. That violates federal minimum wage law, and that can land you in trouble with both the federal government and the state. So that's where, I mean, that scenario that you set up sounds like a recipe for disaster.
So you'll be calling me after the show to get names and numbers for the
absolutely
class action.
Unless I'm paid off in boxes of cookies.
Is that an ambulance I hear?
I'd like a lifetime supply of cookies.
We're cheap. Well, that's I mean, I think would probably be very easy to get in trouble with if you're not aware of what you can and can't do when it comes to contractors.
Yep, absolutely.
Speaking being aware of what you're doing, parents want Welch's. You know Welch's grape juice.
Yep.
To stop selling children fruity candy like it's actual fruit. QZ.com telling us that if a snack box is decorated with pictures of fruit, says its contents are made with real fruit, but only has a little bit of actual fruit inside, can it call itself a fruit snack? Well, that is that is the heart of the case. Now before a federal court in New York in a class action lawsuit brought by parents, like me, who say they bought Welch's fruit snacks because they thought it was a healthy option based on the company's fruit and nutrition-filled messaging both on the box and everywhere else. The nearly 20 products targeted by the suit come in boxes laden with pictures of colorful fresh fruit, phrases like made with real fruit, 100% vitamin C, and fat-free. One of Welch's press release cited by the suit says that nutritional qualities make it a better alternative to a lot of other snacks. Yeah, like sugar, complete like a spoonful. But the suit says that the fruit-flavored snacks are far from nutritious, although the packages list fruit purees, juices, and concentrates as the first ingredients, which would be the most plentiful. The next two ingredients listed are often added sweeteners. On average, sugar makes up 40 to more than 50% of each serving, depending on the flavor. This, argues the suit, is in violation of New York, California, and federal laws. Welch has referred Quartz to the licensed manufacturer, Quartz is the lawyer, to the licensed manufacturer of the fruit snacks, Promotion in Motion, which stands by the products and packaging. It is a fact that fruit, whether in the form of juices or more recently purees, has always been the first ingredient in Welch's fruit snacks. Now, in a statement, it says that our labeling is truthful and gives consumers the information they need to make informed decisions. Promotion in Motion also notes that the snacks meet FDA regulations. The name Welch's Fruit Snacks, however, may also be a problem. Unlike many labeling cases, Ted Craig, a class action defense attorney at Florida law firm Gray Robinson, told the QZ, this case represents a challenge for Welch's because they use the word fruit in the name of the product. According to FDA regulations, you cannot use the common name of a food, for example, fruit, if the product is not actually that food, unless you also display the actual percentages of that food in the product, which the packaging does not. The lawsuit alleges that the packaging also runs afoul of New York and California laws when it comes to labeling products. The lawsuit seeks a number of kinds of relief, including damages for the class members, but the primary goal, says Steve Gardner, one of the attorneys bringing the claims, is to stop these abusive practices. He wants Welch's to stop promoting the products like they have significant amounts of actual fruit in them. He told QZ, our goal is to find a way to let people, parents in particular, know what they're buying. Peter, you and I both have young children. Been here, done this.
Yep.
You're looking at a wall of fruit boxes or fruit juices, and you go, they all say this. Well, let's start reading labels, and it's surprising how many could be misleading.
You know, I think you've got to look at this two ways. Okay, there is because here's my mind, because I guess I deal with lawyers. My mind always goes to, wow, what a scam this is. These lawyers are looking to get rich on this lawsuit. And I can't help it because
just a little bit cautious.
Yeah, I'm slightly cynical. So I'm looking at this packaging right now. And here's what it says on Welch's Fruit Snacks. It says 100% daily vitamin C. That's true. That's accurate.
Yes.
25% daily vitamin A and E. That's accurate. Fat-free, accurate. Gluten-free, accurate. No preservatives, accurate. Then you go to the nutrition label, and the first ingredient is fruit puree, grape, pear, apple, and apricot, followed by corn syrup, sugar, cornstarch, and then it gets worse from there. But I think if you're a parent thinking that you're going to buy a box of fruit snacks and that they're going to have the same nutritional value as an apple, well, then there's something wrong with you. Because, so first of all, I think that maybe Welch's has a problem, maybe because it says fruit, but it depends on how I think the nutritional breakdown comes out, because it is a fruit puree. So what's the percentage of grape, pear, apple, and apricot compared to some of the other ingredients like coconut oil or the sugar? I don't know. They may or may not have an issue. They may have to change it to be something like fruit flavored snacks, and we see that a lot on these gummy things.
Sure.
But I mean, you as a parent, Bob, when you see a package of gummy fruit snacks, do you automatically say, wow, this is healthy for my kids, or do you think differently?
Yeah. Well, honey, you need potassium. Well, let's get the banana flavored gummy bears. And it's always, like you, buyer beware. What are you buying? First of all, anything that can sit on the shelf for longer than a couple of days and not go bad, you should question.
Yeah.
Well, it isn't the order of ingredients has to go from the largest amount to smaller amounts on the nutrition label, correct?
Yes.
So whatever the most of it is, if you're buying sugar, the top item should be sugar.
Right.
But yeah, and that's the funny thing, people this weekend, obviously with the shooting in Oregon, everyone wants to freak out about guns, and I'm not taking this to a gun battle or a gun rights issue, but the fact of the matter is you have to at least read something and figure out, use some logic. And you know what? We all make bad decisions. If you're gonna say guns are the problem, you can say fatty foods are the problem, sugary foods are the problem, inactivity is the problem. They're all based on your accountability, and you have to look at what you're actually buying, because because you're going to buy Goldschlager doesn't necessarily mean that inside the bottle of schnapps is actual gold.
Right.
Although they'll tell you it is. It doesn't matter what you're buying. Labeling is advertising. Advertising is made to make you want something. Sales is making somebody do what you want them to do and when you want them to do it. And they are going to walk that fine line of manipulation. It's what they do, and it's what they do very well. And if, like you said, if you don't read it, then I do it every time. And I look at these. My wife is horrible about this stuff. Why do you buy this stuff? Well, it says this. Well, plus I like it. I said, there is no nutritional value in this. And she does pretty good. I give her a hard time sometimes, and I'm not always the best. But when I come home and I see a box of fruit roll-ups on the counter, well, what are you doing?
Yeah.
We have an apple tree in the yard. You just bought apple slices from McDonald's. Go take a knife and go outside. But yeah, it's like you read the label, you'd be surprised what you're unfortunately going to learn.
Part of the problem, I think, is that even though we're such a knowledgeable and better educated society than we were 20 years ago, yeah, it still blows my mind, though, that basic components of nutrition are above some people. So, for example, you look at this label and you see on the back of the label that there's corn syrup and then there is sugar. Well, you have to understand that sugar is a naturally occurring substance in fruit versus, modified some sort of corn syrup that, you can read all of the detrimental effects of corn syrup, but people don't understand the difference between carbohydrates, proteins, fats, saturated. They don't understand it.
Right.
My sister is one of these people, just doesn't understand. Oh, I thought this was a protein, or I thought this was a carbohydrate. And I think that nutrition is something that really should be introduced into our kids' educational system, whether it's in a PE class, physical education. It should be something that is a little more than just, substance or surface stuff. Don't eat this, don't eat that, don't eat Twinkies.
Sure.
Because if you understood as an adult, okay, what does this mean? But I think, too, that what you said with your wife as an example, I think a lot of times we do know, but it's the taste or convenience. And that's why I've got that cynical edge to me, because, come on, do you really think how many people, I'd love to poll how many people out there will pick up a package of fruit snacks and honestly believe they're getting nutritional value out of it? I don't.
Oh, I think it's scary percentage, I'm afraid.
It blows my mind. But at the same time, you're going to blame Welch's because they have a picture of an apple on the box. What do you want them to put? A vat of corn syrup pictured on the box? Because then nobody's going to buy the product.
Yes. Well, even when you get the fruit flavored, the fact that it says fruit flavored, chances are there's no fruit at all in it.
Right.
It's chemicals designed to taste like a flavor. And we all have our little garbage scenarios where we eat and things we shouldn't eat. Breakfast, for example, for me today. But it's all about, like you say, educating yourself. And a lot of people, especially in education system, the push to teach to the test, and what the students and what the teachers and what the schools are graded on, it's gotten away from what you should learn versus what we're making you learn.
Yeah.
And that's a whole nother story. Yeah, it is. We had health class. I think a lot of our health class was designed more around anatomy. It seemed like, I don't know that we got into simple and complex carbs and diets. So, we always went through the 4 food groups, but what wasn't made an example of was this is by drinking soda pop. How much? If you have two a day, let's say one at lunch and maybe one in the evening, what that's doing to your body, and if you cut that out, how much weight you will lose. It's ridiculous.
Yeah.
Just that alone. And it's that lack of common knowledge education when it comes to your bodies is absent. And unfortunately, we're not teaching adults to do it either. And it's only that's where kids are going to get the answers, and the answers they're getting are wrong.
Well, you know what? You take it to the extreme, and I've seen people in organic health food stores, they'll buy organic brownies and let their kids have the entire package and not understand why their kids are gaining weight. But the brownies are organic. I don't understand. And it's that kind of thing.
Real sugar.
Yeah, exactly. So, I mean, like, you've got to, I think that we as parents, you have the responsibility to look at what you are doing with your children. Look at what you're giving them. And look, I am certainly not a role model for health and fitness. I used to be, but as I've gotten older and less time, I've eaten, bad, and I fall prey to a lot of the stuff that goes on there. I'll be watching a Burger King commercial and it'll look so good, I've got to run out and get one. But I know what I'm doing. It's about willpower, and I know educational wise what's in the product, and I know it's bad for me. But I think that there's a difference between not knowing and knowing and doing it anyway. But is it really Welch's fault here?
Not knowing.
Yeah. But I mean,
I personally myself, no.
I agree with you. I think this is a hard one. I think, come on, everybody knows that fruit snacks, does fruit come in little square gummies or shaped like Bugs Bunny or Yoda? No. But
the only thing you're going to get that's not in its real form is maybe, and that's when I buy applesauce, when I buy apple juice, and when I buy orange juice. I don't buy Sunny D.
Right.
I buy it has a lot of sugar in it. It tastes great. Don't get me wrong. But when I buy those things, especially applesauce, guess what's in my applesauce? Apples and water. That's it.
Yeah.
There's no sugar in it. Nothing. You want to call that organic, go ahead, but that's what I want my kids to have. Do I give them other things I shouldn't? Yeah, absolutely. Not fruit roll-ups. I'm still going to maintain my wife's guilt on that. But when I buy something that's supposed to be healthy, I make sure it's healthy. And my kids may hate me for it someday, and I don't care, because it's called being a parent.
Yeah, and I think that when you get into this idea of bringing in the lawyers and saying, now, you've deceived me. Well, while you're turning over your case to those lawyers, they're going to be saying to a judge, my clients are so stupid that they were misled by the apple on the package. I mean, I know I'm being facetious, but that's essentially what you're saying. I'm too stupid to understand that this is not a fruit product. And so who does this lawsuit benefit? Only one person or group of people, and it's the lawyers.
Yeah, exactly. Yeah. And just to be sure, so the University of Michigan football team are not actual Wolverines, they're people.
That's the next lawsuit.
That's right. Whoa. I thought I'd see some kind of wild animals. Actually, it was the Wolverines and the Badgers. I expected carnage. Brought my shotgun. Pow! Appeals court assigns copyright to the Batmobile. We talked about this earlier. ARStechnica.com, source of this story. Holy copyright law, Batman. So goes the line in the first paragraph of a federal appeals court ruling Gotta love Circuit Court with a sense of humor. Announcing that the iconic Batmobile is a character protected by copyright. The Ninth U.S. Circuit Court of Appeals, probably the funniest thing ever come out of their mouths, sided with DC Comics in its copyright infringement suit against Mark Towell, the operator of Gotham Garage, the maker of Batmobile modification kits. And yes, you can make your Chevette look like a Batmobile. As Batman so sagely told Robin, in our well-ordered society, protection of private property is essential. The three-judge court ruled unanimously, concluding on Wednesday in its 28-page opinion. Here's the highlights. The San Francisco-based appeals court decision largely upholds a 2012 ruling from a federal judge in DC Comics lawsuit that accused Gotham Garage of selling unlicensed replica vehicle modification kits based on vehicle design copyrights from plaintiff's Batman property, including various iterations of the fictional automobile, the Batmobile. The appeals court noted that in 2008, it sided with the copyright of Eleanor, a car with widely identifiable traits that appeared in the motion picture Gone in 60 Seconds. That said, the court held that copyright protection is not always available for every comic book, television, or motion picture character. The judges said it is available only for characters that are especially distinctive. And in the case of Eleanor and in Batmobile, those fictional vehicles qualify. The character must have physical as well as conceptual qualities. It must also be sufficiently delineated to be recognized as the same character whenever and wherever it appears. Finally, it must contain some unique elements of expression. Now, because the Batmobile has appeared graphically in comic books and as a three-dimensional car in television series and motion pictures, it has physical as well as conceptual qualities and is thus not a mere literary character, the court ruled. The vehicle meets the final test because of its status as Batman's loyal Bat-themed sidekick and because it's uniquely and highly recognizable name, the court ruled. What could this guy possibly been thinking? I think I'll just call it, I'll even call it the Batmobile. I can't even believe it made it out of the gate in the first place, even to see a court before it was appealed. But, it goes to, I guess the biggest question is here, Peter, what's the difference between, you talk about, having characteristics, having specific recognizability versus something that might, give me an example if you can, of something that we've seen before, maybe in a picture or a book or on television that isn't copyrightable.
Well, you could say something like, let's stick with the cars for a second. So the movie Transformers, the one by Michael Bay, Bumblebee was I think he was a Camaro, and it's a yellow car with a black stripe going down the center of the vehicle. Now, that was the character that Bumblebee, or that's the model car that Bumblebee scanned and became. Now, is that Camaro something that could be copyright protected? Is that discernible enough to say, when I see that car, I think of Bumblebee? Now, I happen to, and so do my kids, but that's not distinctive enough, in my opinion, to be something that you could protect as intellectual property. It's a Camaro, and it was used by a character in a movie, but it's not the Batmobile, which is in and of itself a completely separate, identifiable, character. It's like Kit from Knight Rider.
So it's specifically designed to be the Batmobile versus the Camaro happened to become Bumblebee. Right, and that's how I view it. The Camaro being a wide-ranging product, sure.
Right. So now if I'm going to sell racing stripe kit that you can put on your yellow Camaro that resembles the Bumblebee car, okay, am I going to be infringing on copyright? I say no. However, you do something like the General Lee, or maybe, and this one's probably questionable, but the van that the A-Team used to drive around in.
Oh yeah, okay, sure.
So I mean, that's one that probably is in a gray area, because with the exception of the red tail fin on top of the van, it could just be a red van. Yeah, exactly. But the Batmobile clearly is definable as a character, as is Knight Rider, Kit. So I think that's really part of the difference.
is the line where you say, let's take the A-Team van. Make your vehicle look like the A-Team van. Is it the use of the term that gets people in trouble?
Well, definitely.
The image.
You definitely think it is. I mean, it's very similar to knockoff designers. So, you go to New York City, you'll be going there in November, and you'll be walking by the street vendors, and everyone will have knockoff Louis Vuitton and Coach. And so there's a whole different area of fashion law that addresses this. But just to kind of put these two ideas together, if I'm selling a bag that looks like Coach, but on it says the word brooch, but it looks identical otherwise, am I violating their copyright or any sort of trademark? Definitely no trademark, because I'm not calling it Coach. And copyright, unless the bag is a work of art versus something that serves a utilitarian function, like a bag, you carry crap in it.
Okay.
So as long as that's what it's for, and mine looks like it, but it's not, but it looks like it, I'm not violating any copyright. If I were to make a knockoff Coach bag that says Coach, that looks like Coach, but isn't, that's a violation. So if I create an A-Team van, and I don't call it the A-Team van, but it looks similar to it, and I just call it a Hero van modification kit, or something like that.
Sure.
Is that infringing? Probably not. I think this is different because, yes, he uses the term Batmobile, but even if you didn't, I think it's a complete knockoff of what this protected piece of property is.
Okay. Well, and here, the next story actually kind of addresses that more. Copycat brand H&M filing a lawsuit against copycat brand Forever 21 for copying one of its designs. The design in question is a tote bag for the beach that cleverly reads, "Beach Please." H&M claiming that a copycat version of the bag conveniently turned up on Forever 21's stores, and after they were being sold at H&M, and they're asking that Forever 21 cease sales of the bag to avoid, believe it or not, tarnishing H&M's reputation. Didn't know they had one, other than copying everybody else. H&M also goes on to allege that the bag has acquired secondary meaning and that H&M is recognized as the original source of the tote bags. Meanwhile, they filed to a federally registered its copyright in the design, which became effective in June of 2015 because H&M values and wants to protect its own intellectual property while exploiting and capitalizing on the IP. Later, H&M filed suit after that registered. So it's the same thing. I mean, if you've seen these bags, they each read "Beach Please."
Right. They each say "Beach Please."
So now you're talking. That's the problem.
I think so, because the rest of it, if you look at the bags side by side, the H&M one is slightly larger, and the way that the palm trees are situated on the bag, there are more palm trees, and they're situated in a different way. And the skyline is a little bit different coloring, okay? On the Forever 21, it says "Beach Please." A little bit different color, different size. But if you look closely, or quickly, I should say, you're not going to know the difference. That's how similar they are. But, is there something you can copyright with respect to the term "Beach Please"? Is that a copyrightable term? And I would argue that
OJ is.
What's that?
Gene Simmons owns the term OJ.
Does he really?
In relation to orange juice.
Gene Simmons from Kiss?
Quite certain of it.
Really?
Yeah, I will.
Wait, I'm losing you, Bob. Breaking up.
No, maybe I better not then.
So wait, I lost you there for a second.
Maybe I won't look for the source.
Okay. We're going to have to look at that because that's interesting. So, I mean, is "Beach Please" something that they could own? I don't know. because certainly beach is not something that you could protect. Please is not something you could protect. But is beach please in this way something that you could protect from a wording standpoint? But then you look beyond that and you look at the design itself. And is there some direct infringement here? You know, I don't know. I mean, I think that this one probably will end up in some sort of settlement because I don't think that a company like Forever 21 would actually fight this all the way to a trial. But it's a tough one because I don't know if this actually is copyright infringement. It certainly looks the same. You know what I mean?
Sure. No. Yeah. Well, and that's the thing. It's how how do you look at it? And it's you go back to the Batman case. Is it discernible? Does it take? I mean, is it recognizable as something specific to it?
Yeah, the funny thing about this lawsuit is the fact that H&M is known for copying everyone else's designs. So does that have any sort of practical weight in this case, that H&M is someone that I think the term that I've seen in some of the articles is that they take quote unquote inspiration from the runway, and then of course they create what I would consider to be knockoffs. So isn't that not only ironic, but does that have any sort of practical bearing in a lawsuit where a judge is going to say, well, wait a minute, you're guilty of knocking off others, and now you're going to blame or criticize another company for knocking yours off? I don't know. That might have that might have some merit to that argument. But I think that you'd have to really look at this case and apply the law, because while the bags are similar, I think if it didn't say beach please, there would be absolutely zero issue. Or if it said, take me to the beach please, I don't think that would have. It's just the fact that they both say beach please. That's the only thing in my mind that makes them similar.
Well, they will find out.
Yeah.
I'm looking at my phone as whether or not he holds that copyright. There's conflicting reports. Trying to find a good source on my phone. Meanwhile, I do that. Microsoft. Microsoft it seems like the tech companies are getting hammered right now. They get hit with a gender discrimination suit, according to Forbes.com. Technology giant is being sued by a former female employee for alleged gender bias that resulted in lower salaries and lack of promotions for women at the company. Microsoft, there you go, the latest tech company to be hit with a gender discrimination suit. The tech giant being sued in Seattle federal court by Katie Musoras, who worked at the company for over 7 years. She alleged that female technical employees like her earned less than similarly qualified men because of gender bias. She also claimed that the company promoted men over equally or more qualified women, and that its managers give women lower performance reviews compared to their male peers. Spokesman for Microsoft issued this comment: "We're committed to a diverse workforce." Of course, were they going to say something different? "And a workplace where all employees have the chance to succeed. We've previously reviewed the plaintiff's allegations about her specific experience and did not find anything to substantiate those claims, and we will be carefully reviewing this new complaint." Now, Musoras left Microsoft in 2014, now the chief policy officer for HackerOne, a startup that helps companies find bugs in their technology. She says that what happened to me is not unique. This case will illuminate the broad the broad pattern of decision-making against women. Fundamentally, this is about fairness and equality. Microsoft is not the only tech company to be hit with a gender discrimination suit in the past 6 months. Both Twitter and Facebook were sued in March. Now, Musoras says her suit follows remarks last year by Microsoft CEO Satya Nadella, who publicly suggested that women in technology should not ask for raises, but trust that the system would reward them for it. Now, his remarks elicited obviously intensive criticism, and he later backpedaled from them. I'm not sure if you remember that.
Yeah.
But Microsoft's got to watch. It's how. Here's the thing. How hard is this to prove?
Well, it's not really all that hard to prove, because you look at the working setup of your company, and you can look and say, this amount of men have these higher positions, this amount of women are all underpaid. And then you can actually start going into and looking at and comparing, what's the education of this woman versus this man, and why is this man making double what the woman is making? So it's possible to do it, but while I don't doubt that this is something that could happen, one thing that kind of jumps out at me, again, I'm very cynical, is the comment about Nadella, because I think that when you look at Nadella's comments, and we talked about this, I guess last year when this happened, when you look at his comments, it almost appears as though it could have been taken out of context and that he didn't really mean that. Because for a bright guy at Microsoft to say something like that, that's really stupid. And we don't think, if I recall our conversation last year, we thought that maybe he did not mean that, and maybe it wasn't meant that way. It was more spun. And that worries me, because then you think to yourself, is this again a woman who is unhappy, disgruntled, angry, passed over for a promotion, not because of gender bias, but goes to a lawyer, and the lawyer says, yeah, they've got deep pockets, and remember when Nadella said this, we've got them. And that's what worries me, because tie this in with something that's going on right now, which is the Pope's alleged secret meeting with Kim Davis, who's the ultra conservative that doesn't want to give marriage licenses out to gay people. And the news media, whether you like the Pope or not, they spun this into a secret meeting that he allegedly had with Kim Davis, where he pledged his undying support for her, which is just total spin. That didn't happen. It was concocted by her and her lawyer. Because, lawyers, the devils with the silver tongues, they're able to spin a meeting. The Pope passes her in the hallway, and he leans over and he says, God bless you. That's a secret meeting to a lawyer. And so the lawyer comes up with, it was a secret meeting, and he whispered sweet nothings into her ear, and he said he supported everything that she does. And that's just not true. So you have to worry and wonder and look with some form of skepticism when you see lawsuits like this, because again, is this a money grab? Is that what this is? I don't know, but
yeah. And don't confuse his last name with Nutella either. It's Nadella. Absolutely
different, right? Nutella is made with no sugar, real nuts, and it's a really great product.
Yeah, it has nuts on the front. It should have nuts inside of it, right?
All nuts, right? There's nothing else but nuts in it.
That's right. Ground up, turn into butter.
That's right.
There you go. Yeah, no, it's you get these cases that are, you like to hope that it doesn't happen, and I'm sure it does happen in certain aspects where women or men could be paid less than their gender opposite counterpart.
Yeah.
But and I'm sure it happens, and you would like to think that Microsoft, if Bill Gates is everything he's supposed to be, this wouldn't happen. But you never know. Sometimes things get out of your reach.
No, you don't know. And you're right too, because there are thousands and thousands of lawsuits in this country that are legitimate, where a woman is being victimized and underpaid, and and that's absolutely true. Where I start to develop this sort of skepticism, or I start to question, is when I see a large deep pocket defendant. That's the target, because now why are you going after Microsoft? Maybe they could be completely guilty, but I think that with a lot of lawyers, the play is they're not going to want to defend this. They're going to want to settle this. They're going to want to make this go away. Let me get a quick hit and leave.
We'll wait and see.
Yeah.
We'll wait and see. Regulators, not the kind they're supposed to mount up, sue a weight loss marketer who used lawsuits to stop negative consumer reviews. We've talked about this in the past, and this is a new way to do it. Federal regulators, according to consumerist.com on Monday, continue their crackdown on deceptive, ineffective weight loss products, this time by filing a lawsuit against a company that threatened to enforce a so-called gag clause by imposing fees and filing lawsuits to stop customers from posting negative reviews and testimonials for the products online. The Federal Trade Commission announced today that it filed a complaint against Roca Labs Incorporated. Roca Labs Nutraceutical, that's quite a, just made that word up one day, Nutraceutical, USA Incorporated, and their principles for harming consumers by unfairly barring them from sharing truthful negative comments about the company or its formula and anti-cravings powder. The company represented its products as safe and effective alternatives to gastric bypass surgery, claiming that users could lose as much as 21 pounds in 1 month, and that users have a 90% success rate in achieving substantial weight loss, especially when you control the reviews. According to the FTC complaint, Roca Labs sued or threatened to sue consumers who shared their negative experiences online or complained to the Better Business Bureau. The company claimed that these customers were in violation of a non-disparagement provision of the terms and conditions they supposedly agreed to when buying the products. It's kind of like implied consent. So since 2014, the FTC claims that versions of the company's terms include a gag clause purporting to prohibit customers from disparaging Roca Labs, its products, and employees. Here's what the label reads. You agree that regardless of your personal experience with RL, anything that starts off that way you should have problems with, you will not disparage RL and or any of its employees, products, or services, the policy states. This means that you will not speak, publish, cause to be published, print, review, blog, or otherwise write negatively about RL or its products, smoke signals, plain signs, or employees in any way. This encompasses all forms of media, including and especially the internet. If you breach this agreement as determined by RL in its sole discretion, judge, jury, and executioner, all discounts will be waived and you agree to pay the full price for your product. In addition, we retain all legal rights and remedies against the breaching customer for breach of contract and any other appropriate causes of action. Wow. Talk about a one-sided agreement. Roca Labs used testimonials, don't believe them, folks, and supposed third-party reviews to illustrate the weight loss success consumers achieved with their products. To do so, the company asked for success videos from purchasers by offering to pay 50% of the product's price for providing positive reviews. Payola. If customers post negative reviews, the FTC claims, the company would claim that those users would owe the full price of the products, often totaling hundreds of dollars more than the advertised or actual price paid. According to the FTC, in addition to threatening, fining, and suing customers, Roca Labs' weight loss claims are false and unsubstantiated. The FTC also charges that the defendants failed to disclose that they compensated users who posted positive reviews. The FTC also alleges that in some cases the defendants violated consumers' privacy by disclosing their personal health information to payment processors, banks, and in public court filings. These guys, something else.
Yeah. Now, this is one of those companies completely on the other end where you say, all right, they're doing something improper here. This is real. And, if you look at, you go on to, there's a website that I love checking out. It's called pissedconsumer.com. There are 91 reviews, and every single review has something negative to say. And so when you have that many negative reviews, you know that something's wrong. Here's one that says, I've struggled my entire life with my weight. My insurance does not cover bariatric surgery. I borrowed money 3.5 years ago to try this product. It made me sick and bloated. I now have IBS. When I contacted the company, I was told that I couldn't return the product or get a refund. I reported to Better Business Bureau, and Roca Labs responded with threats of a lawsuit. I did not withdraw my complaint. I have all my receipts and remainder of the product if anyone wants to test it or fill in the cracks in their basement foundation. The company scams so many people the same way the elderly are scammed. Because they know that we're extremely vulnerable, they need to be stopped and held accountable. Now, here is an example of exactly what's being alleged in this lawsuit. Sure. So, this just, and here's another one. This one's kind of entertaining. There's a lot of little bleeps. I can tell you all enough. Sue the bleep out of them. They tried to force feed this bleep product. Sue them for violating your rights. It's like you buy it, and if it sucks, don't say anything. Let's get more people to buy it and take their money. Class action, ASAP. Blank them, and probably their toxic poison-based product. So, I mean, this obviously is somebody who's really angry, but the fact remains
What's
that
the word on the street?
yeah, when you are putting together an agreement and you're going to be forcing customers to abide by that, there are some things that are legal and some things that are not. I mean, years ago, we had a case against Dell that involved an agreement that you received in the package, and it was a non-class action waiver that you received when you received your computer. So you purchased your computer, you don't sign any terms and conditions, you get the computer, and inside the box there are terms and conditions that had a class action waiver. And this was tested, and the courts basically said no, because if you did not want to keep the product because of that waiver, you could have returned it, received a refund for your money, and then you weren't bound by the terms of that contract. This is totally different because they're telling you that they're not going to give you the discount. In fact, they're going to come after you to make you pay full price, and then they're going to sue you or threaten to sue you. That is completely, I think, off from everything that you could possibly do as a company. We talk so often about getting feedback as a business, whether you're an entrepreneur or a large business, and listening to that feedback because of the benefit that you gain from knowing if you're on the right path. They don't want feedback here. They just want money, and they're going to do everything in their power to prevent people or discourage people from posting their honest opinions. And again, there's remedies when somebody goes onto a site like Yelp and they're just angry and they're going to post something that is purely made up, fictitious, scandalous, just because they're angry. You have action that you could take against them. You have recourse as a company if somebody's done something that is meant to interfere with your business or damage your reputation. But if somebody says this product doesn't work as advertised, I think that they should be free to say that. And Roca seems to have gone way, way overboard with this. And if you look at their
faces, man.
Yeah, their site says bariatric surgery alternative, and that's a trademark term on their site. And then they have a story in a video about a guy who reduced his weight from 420 pounds to 205 in 2 years. And of course, over on the right-hand side, it says these inspiring weight reduction testimonials are not typical and results achieved with healthy diet and exercise. Okay. First of all, you stick that here because you think that you're complying with the FDA. That's great, but you're still misleading people. And then they have reviews. This is the best part. They have reviews listed on their website and testimonials, video testimonials, and all these people, of course, love it. It's the best thing ever, but they're not willing to, let people have freedom of speech and freedom of opinion and to comment on whether or not the product actually works. So shame on them.
I don't always believe the FDA, but I will usually trust them if somebody says this is not FDA approved. My first question is, why not?
Yeah. Yep.
So yeah, they've covered all their bases. I love that. Yeah, basically you can't do anything for these guys. Subway, hopefully not in trouble again. Allegedly, they have fired a worker for being HIV positive. Grubstreet.com telling us the federal government's EEOC, the Equal Opportunity Commission, Employment Opportunity Commission, has sued a small-town Subway in Indiana because it allegedly fired a worker who told his superiors he was HIV positive. According to the wrongful termination suit, the employee, whose name is understandably being kept anonymous, told his boss, a manager named Maria Manawat, and her response betrayed some major unease. Well, she asked, What if you cut yourself? Then also wondered aloud, what if our customers find out? She then told him she needed to consult with the district manager of the lawsuit asserts. About a month later, the employee got word from Manawa to the effect that he might be a liability to the company and that they were going to have to let him go. As the EEOC points out, that's against the law. The quote, the agency's attorney who filed the suit states, you can't terminate someone just because you find out they're HIV positive. The employee is asking for back pay and other damages. The EEOC argues that he got fired simply because of ignorance and fear. And to that end, the EEOC hopes that a suit like this makes people understand that saying in a statement, one of the reasons we litigate a case like this is so people recognize that it's against the law. Valid concern or not?
Well, here's the law. The ADA, the Americans with Disabilities Act, says that an individual is considered to have a disability if he or she has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such an impairment. Persons with HIV, both symptomatic and asymptomatic, have physical impairments under the ADA that substantially limit one or more major life activities and are therefore protected by the ADA. It also goes on to say that persons who are discriminated against because they are regarded as being HIV positive are also protected. For example, a person who was fired on the basis of a rumor that he has AIDS, even if he did not, would be protected by law. Moreover, the ADA protects persons who are discriminated against because they have a known association or relationship with an individual who is HIV positive. For example, the ADA would protect an HIV negative woman who was denied a job because her roommate had AIDS. So, the ADA makes this extremely clear. If you're interested in learning more about it, you can go right onto their website, ada.gov. They even explain who is bound by this law, and it's all private employers with 15 or more employees, clearly Subway fitting into that category. So, I think that there's part of me that almost says, well, you know what? If he does have HIV, what if he did cut himself? Is it a risk? But then there's the legal side that says, well, the law is quite clear. As a matter of fact, and this I think is going to be, if they can prove that this person was fired because of the HIV positive status, I think this is a hands down, slam the door, you're going to be fined, because the ADA in their overview of the law says, here is an example. Examples of employment discrimination against persons with HIV or AIDS would include a restaurant that fired a waitress after learning that the waitress had HIV. So
That's a waitress.
Yeah.
That's not food prep.
True. But I don't know that the ADA is going to make a determination about that. It's a very interesting question because it's from I don't know. What would you think? Would you be concerned as an employer?
Yeah, I would be concerned as an employer or a customer. My first thought is with the ADA, in reference to the ADA, is HIV the only communicable disease listed in the ADA?
No, but they have a specific page all geared towards HIV. Only because...
Which is awfully nice and convenient.
Well, I think it's because HIV has such a negative stigma.
Is deadly.
Well, that's true. But I mean, I don't know. I think that there is an exception that I think the ADA has tried to carve out. And I think that this is where this case hinges upon. And the question is, can an employer consider health and safety, which is what we're talking about, when deciding whether to hire an applicant or retain an employee who has AIDS?
Sure.
And they say that yes, that you can establish standards that will exclude certain individuals who pose a direct threat. A significant risk of substantial harm is the actual terminology that they use to the health and safety of the individual or others. If that risk can be eliminated or reduced below the level of a direct threat by reasonable accommodation, then the person can keep their job. So you could argue that even if this person should not have been making the sandwiches, they could have been kept on through a reasonable accommodation to have them clean the tables.
Reasonable accommodation would be not handling anything that could penetrate the skin, wearing the plastic gloves when putting together a sandwich, not necessarily prepping the sandwich, or however you want to delineate that, ringing up, like you said, whether it's washing tables or operating the till. And maybe that they cannot be there by themselves, because that would put them in a position where they may have to use something or a piece of equipment that could create a cut.
Yeah.
This is an here's the question: do you see this getting bigger than what it is, or is this something that happens all the time?
I think it's something that happens all the time that's disposed of quietly because it's smaller companies. But I think with Subway now, I think it will become an issue. But I don't really see this growing beyond what we already have. But here's something that I just read that I think is interesting, because it does not answer our question. It doesn't solve our problem. And the ADA specifically gives you this example. A restaurant owner may believe that there is a risk of employing an individual with HIV disease as a cook, waiter, waitress, dishwasher, because the employee might transmit the disease through the handling of food, which is exactly what we're saying here in Subway. However,
Sure.
HIV and AIDS are specifically not included on the Centers for Disease Control and Prevention list of infectious and communicable diseases that are transmitted through food handling. Thus, there is little or no likelihood that employing persons with HIV/AIDS in food handling positions would pose a risk of transmitting HIV.
Huh.
Now,
So they're saying that it's extremely unlikely, and you can risk yourself with a lawsuit if it happens.
that's what it seems to be suggesting. So, does Subway find itself in a position here where they've fired somebody who has HIV because of fear? And is it very easy now to go back and say, well, wait a minute. The ADA says that AIDS is a protected class. You fired this person because of AIDS. You didn't attempt to make a reasonable accommodation where you could have perhaps put them in a position if you felt as though they were a danger. Like, I would imagine if this guy had cut himself over and over again, he's constantly cutting himself because he's just a klutz with a knife, then a reasonable accommodation might be appropriate. Here, you operate the cash register. But with this analysis that they've done, the listing or the fact that it's not listed on the CDC, I mean, I don't know. I think they're done.
Even if you come to work, I mean, it would be the employer's responsibility as well to ensure that employee comes to work without any open wounds on their hands. So, I mean, you're going to have to go through an inspection point each morning.
Yeah, and that puts an unreasonable burden on the employer, because the employer is not a medically trained, let's go in the back room with next to the bread, strip down and let me examine you, So,
sure.
But see, I think that's where the idea of reasonable accommodation. So, for example, in a non-HIV case, but somebody has a physical limitation, and let's say that you are a warehouse owner and your company ships out. It's like a drop ship facility. So you're using heavy equipment, you're loading up trucks, and you have no office need. You have no office staff need. You've got a secretary, you're good to go. And you've got a gentleman that comes in and tells you when he's hired, or doesn't tell you, whatever the case may be, that he has a disability. And that disability is something protected under the ADA perhaps it's a physical disability, or it's somebody who has maybe severe hypoglycemia, something like that. And this person cannot physically do the work that's required of that position. Could you fire that person because they have a disability, simply because they can't do the work, or how does that work? Well, you'd have to try to make a reasonable accommodation. And if there's nothing you can do reasonably, then you can fire that person. So if you've got an office staff that's completely staffed, you don't need that person in the office, and they were hired to be a warehouse forklift driver, and they can't do that job, even though they have a disability, you can still fire them. That doesn't mean that they're not going to try to sue you. But that's the idea of making a reasonable accommodation. So I think that, I don't know, I don't even know that this case, which is really an interesting question, I don't even think this gets to the reasonable accommodation issue. I think that they look at the ADA, they say that there's no risk noted by the CDC for food handling, but could you carve out an exception there? Could you say food handling is different than food prep?
Sure.
You know,
the likelihood is higher. Sure.
Yeah, I mean, but they also say, they say cook. They specifically say cook in this. I don't know. This is I'd like to follow this one up, because I think what's going to happen is I think Subway will be in trouble here, because I think if you look at the black letter here, the black letter of the law, I think that it's gonna kind of tip in the favor of the person that got fired.
Sure. No, yeah, with the exception, it's specific to restaurants. So
yeah,
we shall see. Is that where we wrap it up?
Let's just do this Paul Walker thing, because I think this is interesting, and then we're going to wrap it up for today.
Sure. Yeah, Paul Walker's daughter, Meadow, files a wrongful death lawsuit against Porsche. Once again, I didn't know that car was going to be deadly. People.com telling us Paul Walker's daughter has filed a wrongful death lawsuit against Porsche, alleging that her father would still be alive today if the company had installed proper safety features in the car when he died. There's the difference. Lawyers for Meadow Walker, 16, claimed the Porsche Carrera GT that her father's friend Roger Otis was driving when they crashed lacked safety features that could have prevented the accident, or at a minimum allowed Paul Walker to survive the crash, according to the lawsuit obtained by People. Specifically, Meadow's lawyers assert that despite Porsche knowing that the Carrera GT had a history of instability and control issues, the company failed to install its electronic stability control system, which they say is specifically designed to protect against the swerving actions inherent in hypersensitive vehicles of this type. In addition to the alleged lack of proper stability control, Meadow's lawyers claim that a defective seatbelt design kept Walker trapped in the car. If it wasn't for this design flaw, the lawsuit alleges, Walker might have been able to exit the vehicle before it caught fire. Now you ask, what? Well, according to the lawsuit, the seatbelt snapped Walker's torso back with thousands of pounds of force, thereby breaking his ribs and pelvis, trapping him in the car, where he remained alive until the vehicle erupted into flames 1 minute and 20 seconds later. Even the fire itself was allegedly caused by a faulty rubber fuel line, according to the lawsuit, which states that absent these defects in the Porsche Carrera GT, Paul Walker would be alive today. Walker, with a passenger in the car with his friend Roger Otis, lost control of the vehicle in Santa Clarita, California, on November 30th, 2 years ago. The ensuing accident killed both Otis and the Fast and Furious actor. Police deemed the cause of the accident was speeding, citing Otis' speed between 80 and 93 miles an hour in a 25, I believe it was, or 35. The amount of damages Meadow is seeking is not listed in the lawsuit. It is with great reluctance, I'm sure, that Meadow Walker has authorized the filing of this lawsuit on her own behalf and as heir to Paul Walker's estate, her attorney told People. Yeah, the biggest thing, I don't know, it's, maybe it was unsafe. Maybe they did some things wrong. I would be interested to know a little bit more about the seatbelt and the in the fuel lines. But the fact of the matter is, this guy's. At what point do we negate negligence when you're driving a vehicle 80 to 95 miles an hour in a 35?
Well, you hit it right
Apparently
on the head.
Never.
You hit it though. Let me go through the elements of a wrongful death claim real quick. You've got to have death of a human being. You've got to have that death.
Check.
Yep. Death caused by the negligence of another or the intent to cause harm. So there's no intent to cause harm, but the negligence thing we're going to hold on to for a second. Then you've got to have
we will.
yes, a surviving family member who suffered monetary injury as a result of the death, and the appointment of a personal representative who can act for the decedent's estate. So when somebody dies, there's a sort of a loss of consortium claim that can be made. If my spouse died, I'd be losing out on her house cleaning and taking care of the children. And although that sounds completely crazy, these are actually legitimate claims.
Sure.
You know, if the husband died, then the wife would have a loss of consortium claim for, no income coming in, assuming that she's a stay-at-home mom. So there's all this different stuff. But let's go back to the main issue, and it's negligence. So you have to undertake a traditional negligence analysis, which is, was there a duty owed by, in this case, the car? Is this Porsche inherently unsafe? Is that the issue? Are they saying that, if they had...
It's a Porsche. Of course it is.
Right. I mean, it's designed to go fast. So,
it's supposed to go fast.
Right. So I think it comes down to, is there a duty owed? Yes. Did they breach that duty? And, it's really hard to say that they breached the duty. I think the fact that they're going to try to go back and say that it's more like a product liability case where they knew that the Carrera GT had a history of instability and control issues, and they didn't install. I mean, this is their only argument that I see, the failure to install the electric stability control system. That's the only argument. The defective seatbelt design, again, I think these are hard arguments to make or to succeed on. You can make them. Making them is easy. It's winning on them. So it'll be interesting to see where this goes. But
Sure.
When you look at the traditional negligence analysis, you're going to have to show that they breach their duty of care to all drivers. And that's going to open up a whole sort of analysis of Carrera GT accidents. And what's the cause of this accident and that accident? And would they have known? Should they have known? Did they breach their duty? But, famously, a wrongful death action. I was just watching some documentary about O.J. Simpson, talking about O.J., which we mentioned today. And
I thought you were going to say you were watching
no, and wrongful death. Just to show you the power of a wrongful death suit, O.J. Simpson, we all know, not
Sure.
convicted of murder at the criminal level, but then Ron Goldman's family brings a civil suit. A wrongful death suit is a civil suit, and they got him for, it was like $20 million in punitives and $8 million in compensatory. They got him because he was deposed. He had to go through the standard civil trial issues, and that wrongful death, they were able to prove that his negligence or his intentional act, his intent to cause harm, and they hit gold on that. But so that
which I still don't understand how.
yeah. Well, the gloves didn't fit, so you had to acquit. But I think
right.
I think that just the idea of a wrongful death suit, people don't understand that it hinges upon negligence or intent, but it's not criminal. So that's interesting. Before we wrap up, I just want to make one comment about this Volkswagen thing that was big in the news.
Oh,
so,
yeah, huge.
Everybody knows Volkswagen, and what they allegedly, and it's actually more than allegedly, but what they did is they created software or device that would sort of mask the failure of the car to perform up to emissions standards. So they essentially committed fraud. I don't know how else you say this in a nice way.
Yeah.
So, the issue...
They willfully did it.
Yeah, they absolutely
Someone
did. Right, and someone did. And there was an interesting article talking about leadership and what you can learn from what has happened with Volkswagen. And they argue in that article, and that was from entrepreneur.com, they argue that when you do something this fraudulent on such a large scale, it's not one person, it's a group of people. And you have to wonder, what was Volkswagen thinking when they did this? And clearly they were thinking they wouldn't be caught. But how could you have that thought in today's modern society? And it's amazing.
The interesting thing to me about and how long it took to get out. So either somebody squealed or somebody figured it out.
Yeah.
And the old adage is that if more than two people know something, everybody knows it.
That's true.
And I have to. If you take this, there's two things that come to mind. One is the VW thing here, which was obviously blatant. There's no way around it now. Just decide who was responsible for it, and the GM ignition system,
right,
with the keys, and how more than one person said, "Oh, this pin's too short. We need to change the pin and make it longer." And the standard practice is you revise the part number, and it goes through engineering change. I've been in manufacturing. I know how it works. And they didn't. So more than one person knew what was going on there and didn't say anything. And it took a private investigator, I think, to go get an ignition, I think is what I had seen on an article, was where he went and actually dug up salvaged ignitions out of the junkyard and took them apart and realized that, hey, this piece is longer than that piece, but it should be the exact same.
Right.
And so someone figured that out. And the corporate structure in both of these two cases is amazing to me, that it didn't appear to come from within, that somebody blew the whistle.
Right. Right. So you don't know what, limitations this knowledge had. Was it a group of 5
Right.
people? Was it a group of 3 people? So that part of it was kind of kept under wraps, surprisingly. But what just blows my mind is that a company like Volkswagen, known for quality, also known as the car of the Führer, but we'll leave that for another day. How could they do something so stupid? And does it hurt their credibility as a company, or do we all forget about that in the future? What do you think?
I think it's going to be one of your better stock buys.
Why do you think that?
Wait till it's going to continue.
You think it's going to drop?
It's going to continue to drop. And once they get everything figured out, it will come back. Volkswagen's got a great name. They make a great product. It's just a hiccup in the road. People will forgive them.
See, I think that too. And I think
why? I don't know.
Right. I mean, look, you've got a company that, what else are they going to lie about? I mean, look, if you were putting these people on the stand, right, and they're lying to you at trial, there's that false in one, false in everything Latin phrase that we use at trial. In a jury instruction that says, if you're lying about this, it's conceivable that you're lying about everything. How do we know that we could ever trust Volkswagen?
Sure. Well, you look at, they're not the first person to mess things up.
True.
And unfortunately, nothing comes to mind, but I know they're not alone. And my first thought is Iacocca. They didn't necessarily trick people or do something horrible and kill people or purposely defraud the government. But what they said was, hey, you know what? We messed up and we are out of cash. We need help, but we're coming back better than ever. And they did. And everybody forgave them. Unfortunately, they failed again. And everyone forgave them, and then they failed again. Yeah. And now they're an Italian company. Ta-da! Now for my next trick. So it's been done before. It'll be done again. The probably the best and worst thing to happen is Winterkorn leaving. He says, you know what? It either happened under my watch and I didn't know about it, or I knew about it. Either way, I'm out of here. It's going to be a big house cleaning. It's going to be a big PR mess. But eventually, they will come back. Yeah. Germany is too well respected in the manufacturing world not to. You're talking about the home of Mercedes-Benz, Porsche, for crying out loud.
Yeah, absolutely. Absolutely.
There you go.
Oh, well, that's going to do it for today. We've got a bunch of Supreme Court cases that are coming up that we're going to have to look at. There's Evanwall versus Abbott, which is a voting rights case. There's the issue of abortion. There's an affirmative action case, Fisher versus the University of Texas at Austin. There's a union dues case that they're going to be looking at, Fredericks versus California Teachers Association. So we're going to keep an eye on those. But today is the first day of the new term for the Supreme Court, which is why I'm raising this. Something that we'll probably be discussing at the close of the term next year, and having some comments. And we talked last year, if you remember, or I guess it was in the spring, there was the Confederate flag on the license plate and a bunch of other things that were interesting. So we'll see what the Supreme Court does with these issues this year. All right, that's going to do it.
As I get older, I'm less excited about the NFL starting and more excited about SCOTUS.
That's sad. That is sad.
And I don't know if you caught Judge's Draft Day, but man, it was exciting. Covered on Court TV.
Speaking of football, just as an aside, why
Talk about the Lions.
Why do they go to England to play football? And why was the Jets game at 9:00 in the morning? Because they're in England. Why?
First, to answer your first question, branding and marketing, they want to expand over there. It's all about money. And second of all, they aren't going to play at 4 a.m. or midnight to make the 8 p.m. time here. So they're going to play in the middle of the afternoon again for TV time. So it all boils down to money, Peter.
It's so sad. I was quite surprised though, because I taped the game and I was looking to see how packed the stadium would be, and it was packed. So interesting.
They bring them in. Yeah,
it's just interesting, but very annoying. Although I am glad the Jets won. I happen to be a Jets fan, so there's some good news out of the weekend.
They try to expand their brand, and as the U.S. tries to get rid of the brand. I find that interesting, and switch over to soccer.
Yeah.
Fast backwards as always.
That's right. All right, well, that's going to do it for today's show. We've got our legal question and answer coming up tomorrow, followed by Wednesday's business Q&A, and then we have our interview show on Thursday. If you missed any of the shows last week, what we did is a Friday recap podcast that kind of went over all of the important things that you missed on the prior days. It's well worth checking out because last week we had a really, really good interview on Thursday and a lot of really great high quality information that came out of that interview concerning marketing and branding and how to develop your business. I'm not going to even tell you who the guest was. You've got to go and look that up. That is available on UTLRadio.com. It's also available on iTunes. So if you haven't subscribed to the podcast on iTunes, please make sure you do that. That way you're notified when new episodes are published. And don't forget that there's a YouTube channel that has different content than the podcast. Bob and I ramble on Mondays. We talk about all these news things and our opinions. And that, you're going to find a live broadcast on YouTube if you're interested in listening to the whole thing. But during the week, there's other videos that are not related necessarily to the podcast. So just because you subscribe to the podcast or to YouTube doesn't mean that you're getting content on the other mediums. So make sure you subscribe to both. Check out UTLRadio.com. We will be back, Bob and I, next Monday with another week in review. Don't forget to tell your friends, family, colleagues about UTLRadio.com, your business success and legal information station. I'll see you next time.